Legal did a how the Supreme Court killed Roe v. Wade. Okay, let's, fuck it. Let's watch this.
Put it. Roe versus Wade and its progeny are dead. Women in the United States no longer have a constitutional guaranteed right to an abortion. This video explains the how and the why of everything that happened. And to do that,
I hope he goes into the history. Oh, he just said, okay. Well, now we know, dude. Okay, now we know he's going to go into the history of how it happened, okay? So dumb, dude. Yeah, I pre-watched. You didn't pre-watch the top of the hour ad break, though, which comes at the top of every hour. 60-second ad break. And if you no longer want to see those ads, all you need to do is subscribe for $5 or for free with a Twitch Prime. By connecting your Amazon Prime account to your Twitch account, you get one free Prime subscription a month. Use it on your favorite broadcaster. Hopefully, I am your favorite broadcaster. Your favorite Twitch streamer. That's right. You can also get gifted a sub, by the way. That's another method, a strategy. Avoid the top of the hour ad break. Strategic method, if you will. Here's the 1 minute ad break now.
Have to start with the history of how we got Roe versus Wade in the first place. What is the source of a constitutional right to an abortion in the United States? It is one of the rights which fall under a general right to privacy, which is the right of people to make personal decisions regarding intimate matters. Now, when you're talking about the right to privacy, you're talking about unenumerated rights in the Constitution. When the founders were drafting the Constitution, they did not set out to list all of the rights which Americans could conceivably claim. They were well aware that by naming some of the rights but not others, future governments might deny the people rights that the founders believed were important. And this is why the Federalists originally did not want a Bill of Rights to be included in the Constitution itself. And as a compromise, rather than make a long list of rights, the founders included the Ninth Amendment, which states, quote, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." James Madison, in particular, reportedly said that the government should never use the Bill of Rights as an excuse to increase its powers over areas of life that were not enumerated in the Constitution. Now, the Supreme Court really began fleshing out unenumerated rights in the mid-20th century, particularly in a case called Griswold versus Connecticut, which voided a statute that made it illegal for married people to buy contraception. The court wrote that privacy was one of the values implied by the First Amendment, which protects the right of association between people by the Fourth Amendment, which allows people to be secure in their persons from government intrusions, and through the 14th Amendment's guarantee of due process. Now, in that case, after reviewing a line of cases in which the Supreme Court identified rights not explicitly enumerated in the Constitution, Justice Douglas argued that the court could infer a right of privacy by looking at zones of privacy protected by other parts of the Constitution in overlapping protections. Quote, "Various guarantees create zones of privacy. The right of association contained in the penumbra of the First Amendment is one, as we have seen. The Third Amendment in its prohibition against quartering of soldiers in any house in time of peace without the consent of the owner is another facet of that privacy. The Fourth Amendment explicitly affirms the right of the people to be secure in their persons, houses, papers, and effects."
When this motherfucker said the history, I didn't realize he was going to talk about the history of fucking like Griswold v. Connecticut and shit. I thought he was going to talk about the history of like how the Supreme Court became a reactionary powerhouse.
Against unreasonable searches and seizures. The Fifth Amendment in its self-incrimination clause enables the citizen to create a zone of privacy which government may not force him to surrender to his detriment. The Ninth Amendment provides the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people.
He's literally doing a constitutional law class right now.
Upheld the right of married couples to decide private issues of contraception, and 7 years later, Eisenstadt versus Baird extended Griswold's holding to unmarried people, using some of the same logic. And following Griswold, the court upheld a right to privacy and struck down a number of laws, including those prohibiting interracial marriage. The Constitution does not explicitly say anything about marriage, and in the mid-19th century, the law offered interracial couples no protection, even from prosecution. In Loving versus Virginia, the court held that a Virginia law criminalizing interracial marriage violated the Due Process Clause of the 14th Amendment. Chief Justice Earl Warren wrote, "Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state." And continuing with that logic, the court also relied on the 14th Amendment's due process laws to strike down laws banning prisoners.
For the record, like, all of this shit is made up, okay? Make no mistake. I want you to understand, like, the attitude that people have towards abortion right now, or the way that they fucking feel about, like, interracial marriage was different back then. And it was made up. Motherfuckers were like, yeah, no, you shouldn't be able to do that, okay? That's what a lot of people thought. And then the Supreme Court decided, no, That's not the case. And it was made up when it was positive in those decisions, and it's still made up now when it's negative in the decisions that came down in this last term.
From getting married while in prison. And continuing in those line of cases, in 1973, Roe versus Wade established a constitutional right to an abortion through the Fifth Amendment, among others. Now, the Fifth Amendment says no person shall be deprived of life, liberty, or property without due process of law. Now, courts have interpreted two types of due process. One is procedural due process, which are the rules that the government must follow, such as giving a person notice, a hearing, and a fair tribunal. And then there's what's called substantive due process, which is the idea that allows courts to establish and protect certain fundamental rights from government interference, even if procedural protections are present or the rights are unenumerated. Now, the Roe opinion begins with a long review of the medical history of abortion. It reviews the history of abortion laws, finding that many prohibitions on abortion were relatively modern. The court reviewed many religious and philosophical traditions, which contain many different views about when or if the unborn could be considered people during different stages of pregnancy. And the court ruled that the word person, as used in the Constitution, did not include the unborn. The court concluded that the 14th Amendment's concept of personal liberty includes a right of personal privacy over certain areas, which include whether a woman terminates a pregnancy or not. And the court also recognized that the government could not make a choice about whether the person continues a pregnancy. And the court held that the state had valid interests that justified regulation of pregnancy and that the state's interest increased as the pregnancy progressed. Then, almost 20 years later, the Supreme Court decided another abortion case that substantially revised Roe. That's Planned Parenthood versus Casey. That case tested whether states had the right to restrict abortion, including during the first trimester. The Pennsylvania regulations included a mandatory waiting period, spousal notification, and parental consent. In the Casey decision, the Supreme Court overturned Roe's trimester rule in favor of a viability analysis and lowered the standard of review for abortion restrictions from strict scrutiny to an undue burden test. And under Casey's undue burden test, abortion restrictions were unconstitutional if they had the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus.
Okay, guys, it's not that complicated. Jesus Christ, you're like exaggerating, I hope, with like how difficult this has been for you to comprehend. I hope you're exaggerating. This is like pretty basic. I mean, this is like pretty basic stuff overall. I hope you're joking. God damn.
The court held that states could require parental consent for a minor's abortion, require waiting period between seeking and obtaining an abortion, and require detailed, informed consent, including medical information about the abortion. But the state couldn't require a woman to sign a form stating that she had given notice to her husband that she was having an abortion. And again, following in these cases, in 2003, the Supreme Court cited Loving, Griswold, Eisenstadt, Casey, and Roe in striking down a Texas law that criminalized sexual intimacy by same-sex couples, but not identical conduct by straight couples. The court held that the law violated the 14th Amendment's due process clause, as adults are free to engage in private conduct in the exercise of their liberty under the due process clause. Quote, their right to liberty under the due process clause gives them the full right to engage in their conduct without intervention of the government. And notably, Justice Scalia dissented in this case, stating that the logic of the decision would, of course, permit same-sex marriage.
My favorite. Yeah, it's so good. The state cannot demean their existence or control their destiny by making their private sexual conduct a crime. Their right to liberty under the due process clause gives them full right to engage in their conduct without intervention of the government.
Marriage. And in 2012, following in that case, the court proved him right by legalizing same-sex marriage, citing the same string of cases that established the right to choose.
Wait, I want to show you guys Scalia's dissent on... I'm not even fucking kidding. Okay? I'm not even kidding. When I read Scalia's dissent, I realized, oh shit, these guys are just making it up as they go along. Huh. Okay, here. Mother Jones has a good article on this. Here are the 7 worst things Antonin Scalia has said or written about homosexuality. Okay? Flagpole sitting. In 2003, during oral arguments in Lawrence v. Texas, the case challenging a Texas law that criminalized homosexual sex, Scalia came up with a tasteless analogy to illustrate the issue. Suppose all the states had laws against flagpole sitting at one time. You know, there was a time when it was a popular thing and probably annoyed a lot of communities, and then almost all of them repealed those laws, Scalia asked the attorney fighting the Texas law. Does that make flagpole sitting a fundamental right? Let's throw gay people in jail because some people don't like them. In his dissent in Lawrence, Scalia argued that moral objections to homosexuality were sufficient justifications for criminalizing gay sex. Many Americans do not want persons who openly engage in homosexual conduct as partners in their business, as scoutmasters for their children, as teachers in their children's schools, or as boarders in their home, he wrote. They view this as protecting themselves and their families from lifestyle that they believe is immoral and destructive. Some people think obesity is immoral and destructive. Perhaps New York Mayor Michael Bloomberg should have imprisoned people who drink sugary sodas rather than trying to limit the size of their cups. Laws banning homosexual sex are like laws banning murder. In his dissent in the 1996 case, Romer v. Evans, which challenged Colorado's ban on any local jurisdictions outlawing discrimination on the basis of sexual orientation, Scalia brought out an analogy that he's used to attack liberals and supporters of LGBT rights for years since. Of course, it is our moral heritage that one should not hate any human being or class of human beings, Scalia wrote. He's not hateful. He's not a hateful piece of shit. But I had thought that one could consider certain conduct reprehensible. Murder, for example, or polygamy, or cruelty to animals, and could exhibit even animus towards such conduct. Surely that is the only sort of animus at issue here. Moral disapproval of homosexual conduct. He said human beings should feel the way towards gay people as they do towards people who engage in acts of polygamy, cruelty to animals, and murder. One of the grossest things you can ever do is compare gay people to Mormons. That is really fucked up, Antonin Scalia. How dare you? Scalia decided to take the moral disapproval argument up a notch in his dissent in Lawrence, writing that the Texas ban on homosexual sex undeniably seeks to further the belief of its citizens that certain forms of sexual behavior are immoral and unacceptable, like laws against fornication, bigamy, adultery, adult incest, bestiality, and obscenity. Scalia later teased up prostitution and child pornography as other things he thinks are banned because, simply put, people disapprove of them. This is a Supreme Court justice, folks. I need you to understand. This is a Supreme Court justice who wrote this stuff that is being taught in schools now. Okay? And he fundamentally misunderstood, or rather, because he was a bigoted, hateful piece of shit who is dead now. Okay? Thank God. Holy fuck. Rest in piss. You are burning in fucking hell. You disgusting slime bag. But this person not only had the capacity to fundamentally alter millions of people's lives, but he also got away with saying stuff like this, okay? And not only did he write this sort of shit, okay? He fundamentally misunderstood the main reason for why there are laws against child pornography. People don't just simply disagree or disapprove of child pornography. That is a self-report, okay? Like he's saying, if people didn't just simply disapprove of child pornography, then it would be appropriate to consume. Okay? Understand that. Like in his fucking psychotic libertarian brain, he's just saying like, well, people just simply disapprove of bestiality and child pornography. He's like, no, man, it's called harm. It's harm to the child. Okay? Whereas acts of, homosexual acts of love or expressions of love is not actually harming anyone. That's the difference. Okay? He said homosexual couples are like roommates, not content to analogize laws singling out people on the basis of sexual orientation. Scalia suggested in his dissent in Romer that the relationships of same-sex partners were comparable to those of roommates. Colorado's ban prohibits special treatment of homosexuals and nothing more. It would prevent the state or any municipality from making death benefits payments to the life partner of a homosexual when it does not make such payments in a long-time roommate of a non-homosexual employee. That's the funniest thing. Like, they're such fucking pieces of shit. He also, during oral arguments in Lawrence, the attorney challenging the Texas law, argued that it was fundamentally illogical for straight people to be able to have non-procreative sex without being harassed by the state, while same-sex couples did not have the right to be free from a law that says you can't have any sexual intimacy at all. But Scalia pointed out that gays and lesbians could just have sex with people of the opposite sex instead. Man, he was such a woke guy. And just another big fuck you, for the record, to RBG, croaked and didn't retire. Ruth Bader Ginsburg.
Agreement on lots of things. Justice Scalia answered, I attack ideas. I don't attack people. Some very good people have some very bad ideas. And if you can't separate the two, you've got to get another day job. You don't want to be a judge, at least not a judge on a multi-member panel.
Anthony Scalia was like, I separate the art from the artist. You know what I'm saying? Like,
well-known illustration. Justice Scalia was very fond of Justice Brennan, as Justice Brennan was of Justice Scalia. I will miss the challenges and the laughter he provoked, his pungent, eminently quotable opinions, so clearly stated that his words never slipped from the reader's grasp. The roses he brought me on my birthday, the chance to appear with him once more as supernumeraries at the opera. In his preface to the libretto of the opera buffo, Scalia-Ginsburg, Justice Scalia described as the peak of his days in D.C. an evening in 2009 at the Opera Ball at the British ambassador's residence, when he joined two Washington National Opera tenors at the piano for a medley of songs. He called it the famous Three Tenors performance. He was indeed a magnificent performer. How blessed I was to have a working colleague and dear friend of such captivating brilliance, high spirits, and quick wit. In the words of a duet for tenor Scalia and soprano Ginsburg, we were different, yes, in our interpretation of written text, yet one in our reverence for the court and its place in the U.S. system of governance.
now this was leading up to the 2013 decision, so I'm trying to find the I'm trying to find his like memorable bestiality, like likening the slippery slope argument of like, if man is allowed to marry man, then what's next? Can man marry a dog, a beast? That's what I've been looking for on this side. Which is like, RBG definitely giving that sloppy gluck like the Scalia in heaven right now. You think either of those dumbasses are in heaven? My friend, you are mistaken. Okay? They are both burning in hell, motherfucker. So if she's giving the Gluck 2000, 3000 to fucking Anthony Scalia, it's definitely in hell. Oh. Yeah, I mean, he did. He said we basically covered it. He did make a, he said that he compared same-sex marriage to, Chief Justice John Roberts suggested in dissent that the decision puts on a slippery slope of protecting a right to a plural marriage or polygamy. Chief Justice Roberts suggested in dissent. Wait, I thought that was Antonin Scalia. What the fuck? Dude, and if you're wondering, like, why is the Law and Public Affairs Princeton University seminar is currently saying this shit? Okay? If you're wondering why, well, the answer is simple. It's because lawyers are fucking debate perverts, okay? That's why. And every debate pervert ultimately has to talk about bestiality and pedophilia and child pornography. And lawyers are debate perverts. They get paid to be debate perverts, okay? The Supreme Court justices are the biggest fucking debate perverts. And unfortunately for all of us, it is the most consequential type of debate pervertry. Understand? Yeah, Justice Scalia protested in his dissent that in the case effectively decrees the end of all morals legislation. Is Scalia right that there's really no distinction between same-sex intimate association in the quotas list, bigamy, same-sex marriage, adult incest, prostitution, masturbation, adultery, fornication, bestiality, and obscenity? I love that his take has like a charcuterie of things, some of which are totally acceptable and appropriate, and some of which are just completely fucking horrifying. Like, how can you, without even consideration, put masturbation and child pornography on the same fucking list, dog? Like, even you can even say, like, okay, prostitution is controversial for many old folks, okay? Fuck these people. But, like, and they're wrong for having this approach. But masturbation, motherfucker, like, that's old school as hell. His Google searches. So just remember, if you think that these guys are like incredibly brilliant or whatever with their opinions, well, they're fucking wrong. Okay? You're wrong. You're wrong to think that they're brilliant. They're fucking psychos, okay? They're complete fucking psychos. They're just as dumb as any other fucking dumb debate pervert that you know. They're just making shit up as they go along.
Choose one's intimate relationships.
They aren't even debate perverts, though. There's literally no logical connection between a gay couple marrying to marry an entirely different animal species. You can't logically make a sensible conclusion. What? They're using logical fallacies, which is being a bad debate pervert? Dog, that's what debate perverts do. Hello? Are you new here? Like 90% of debate pervertry on the internet is trying to hyper-rationalize your logical fallacies, dude. What the fuck are you talking about? No, that's exactly what debate perverts do. You might be one, my friend. That's why every debate pervert goes ad hominem in instances where it doesn't apply. That's why every debate pervert loves using like, oh, this is a straw man when it doesn't apply. That's like, they don't know anything. They don't know any nice anti-intellectualism. See, there you go. We got another one. Every time I bring this shit up. That's not anti-intellectualism, you fucking idiot. What is anti-intellectual is literally acting like there is any sort of moral consistency in any of these fucking arguments. Especially if you're watching it on fucking YouTube, okay? Like YouTube debates and shit.
And whether to have children. And when the court decided that case, Obergefell versus Hodges, it observed that if a person has the right to choose whether to have an abortion, then they have the right to marry the person of their choice. Now, in the aftermath of Planned Parenthood versus Casey, states enacted more and more restrictions on the right to an abortion. Over the years, federal courts have analyzed nearly every kind of abortion restriction imaginable, invalidating some of them and upholding others. But one thing never changed: the court's original ruling that the right to privacy included the right to a legal abortion. But the recent case of Dobbs versus Jackson Women's Health Organization changed all of that. The Jackson Women's Health Organization brought this lawsuit to challenge the constitutionality of Mississippi's Gestational Age Act, which
HasanAbi, for a leftist chat, your community sure does like to call everyone R words when they have a simple question. Okay, I'm done. Doesn't seem like you're done. You keep fucking asking the same question over and over again. What's the question? Your chat's full of douchebags. You don't even have a question, dumbass. What's your question? Ask your fucking question instead of fucking crying about how dumb people are being douchebags to you. Where is the question? Ask your fucking question. Go ahead. Come on. Derail further. Derail further. Go ahead. Go ahead. Go ahead. I'm waiting. What is your question? Like, incredible, dude. Incredible that you're not even fucking, like, about Saudi Arabia. So it wasn't even a question that you personally had, considering that you haven't actually even asked the question. You're literally upset for other people? You still have yet to ask a question, dude. I don't know a lot about these things. It's okay. Or asking about what the justices did and why we hate them. Okay, ask away. Ask away. Stop defending other people, like asking questions and then people yelling at them, okay? Jesus Christ. Why debate perverts are annoying? To prove your work takes 1 second to ask and 7 hours to fucking complete. And the person who always asks you to prove your work is never even interested in changing their mind or cares about how you prove your work. That's why I hate debate perverts. It's so easy to fucking derail and just be like, actually prove your work. What if it was what if the light switch turned on because of a consequence of holograms? Like, they literally, that's a thing. You can technically say that. To prove your work, take. Anyway, don't yell at this chatter for derailing the stream. Why did Justice Scalia seem bad? Okay, you're fucking kidding me, right? Did you just not see? What? Okay, don't yell at the person. Don't yell at the person, okay? Don't shit on the person. I think they're baiting. There's no way. Like, or maybe they're really young and they're like a kid or something. My friend, did you just hear all of the times where I read like all the fucking legal documents where Antonin Scalia compared gay people to like fucking dogs and shit or child pornography? Do you think that that constitutes for like a bad person? Maybe you're asking questions that I'm already covering, and you know, I'm all in. Look, I'm in favor of like answering all manner of different questions, right? I'm always trying to fucking help out. But you're asking questions that are in the process of being Look, I'm not fucking schizo. Just call me a schizo. That's cool. No, I wasn't able to hear that. I was out for that time. I just got to jump in. And yes, based on that, he does. Okay. You're not. No one said you were. Calm down. Okay. Stop reading the chat. Chat, stop being mean to that person. Okay.
Which states, except in a medical emergency or in the case of a severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. Jackson Women's Health was the only remaining abortion clinic in the state. The organization won at the federal district court level, and the district court decision was upheld by the Fifth Circuit Court of Appeals. Mississippi appealed to the Supreme Court. Now, some legal commentators expected the Supreme Court to simply overturn Casey's viability analysis and replace it with a right to an abortion that stops at 15 weeks. And in fact, this is what Justice Roberts advocated in his concurring opinion. However, a majority of the Supreme Court decided to overrule Roe and Casey from the roots and allow each state to decide whether there is a right to an abortion or not. The majority opinion was written by Justice Alito, and the vote to overturn Roe was 5-4. Justices Thomas, Gorsuch, Kavanaugh, and Barrett joined Alito's opinion. Chief Justice John Roberts did not join in the opinion in overturning Roe, but filed a separate concurring opinion which he agreed with the result, which is why you'll see some people call this a 6-3 decision. Justices Kagan, Sotomayor, and Breyer dissented. Now, Justice Alito's opinion begins by stating that abortion presents a profound moral issue on which Americans hold sharply conflicting views. The Constitution's text does not refer to abortion. Alito concedes that not all rights recognized by the court have to be mentioned in the Constitution's text. As I explained earlier, the court has held that due process guarantees of the 5th and 14th Amendments protect certain substantive rights that are not listed in the Constitution. The general idea is that certain liberties are so important that the state cannot infringe on them without a compelling reason, no matter how much procedural due process is given. And Justice Alito states that the Due Process Clause protects the right to interracial marriage, the right to use contraception, and the right to same-sex marriage, but it does not guarantee the right to abortion. Why? Well, according to the majority, the test for unenumerated rights is whether the right is deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty.
Wait, but like the nation has never had a deeply rooted fucking history of allowing interracial marriage. If anything, the nation's deeply rooted history is white supremacist, so why not loving? Oh, it's an arbitrary distinction they decided to place upon abortion, especially because it has no historical basis. That's the worst part. Abortions were commonplace. Fuck. That's fucking, even in their own rules that they create, they lie. Their own fucking rules that they're setting for no reason. It's a game that they're playing with each other, where they have set these fucking fake boundaries, these arbitrary distinctions, these fucking psychotic debate perverts. This is why I say all the time, if you're a debate pervert, inshallah, one day you will suffer. One day. For the rest of your fucking life. I hope it is miserable. I hope your family is cursed for 7 fucking generations. Okay? You are destined to suffer, to even feel a fraction of the suffering you put upon so many people. They make up fake fucking rules, and even in the fake fucking rules that they're putting forward, it's still not consistent. It makes me so mad.
And according to Justice Alito, abortion doesn't qualify under that standard. And in setting forth this test for which unenumerated rights are permissible, Alito cites Washington versus Glucksberg, the case which found that there was no constitutional right to a physician-assisted suicide. Abortion is like assisted suicide because, according to the majority, neither can trace their roots to the founding of America. The Alito opinion goes on at great length about the history of abortion in America. He states that until the latter part of the 20th century, such a right was entirely unknown in American law. And indeed, when the 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages of pregnancy. And the majority opinion says that the 50 years between Roe and the present day do not carry any weight in establishing that that right is deeply rooted, or that women relied on it in organizing their lives. The majority opinion concludes that Roe's holding that abortion was a liberty interest protected by due process was incorrect. The Roe decision said, quote, "The right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is, or as the district court determined in the 9th Amendment's preservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy." Now, Alito criticized the justices who wrote this, saying that they couldn't really put...
I love the fucking horny Turks, dude. Horny Turks literally are like, they're like, come on, kızlar geldi, kapıyı aç abi. They've been sitting in here being like, I don't even know what the fuck this motherfucker's talking about, but I heard there's going to be some girls on the broadcast later, so I'm just been sitting here listening to this dumbass talk about fucking kürtaj mı? Ne diyor la? Kürtajdan mı bahsediyor? Ne konuşuyor abi bu ya? Ne diyor amına koyayım? Hadi abi, karılar nerede? Aç, meme aç. Meme aç. Porno aç da izleyek amına koyayım. Like, he literally just said, the girls are here. Come on, open the door. Open the door. Like, they're not here. There's like motherfuckers in here, straight up, bro. I swear, this is so funny. There are dudes in here right now, okay, that are specifically in here because they want to watch these. They want to watch. They're like waiting for these girls to come over, okay. And what's hilarious about this is that they have to sit through all this abortion talk.
Put their finger on the nature of the right, and it was decided on feelings. And there's always been controversy about that. In fact, many commentators have argued that the court made a mistake in grounding the right to an abortion in the substantive due process clause. Justice Ginsburg argued that the court should have decided Roe based on the Equal Protection Clause
Rest in
or
peace.
the Privileges and Immunities Clause, which would have provided more durable protection of the right. And in Dobbs, several...
I hate that this lawyer keeps putting so much emphasis on meaningless dicta, which has no bearing on law or precedent. It's just pacifying bullshit to keep liberals from panicking. No. I mean, this is how it's taught. This is how liberals fucking learn shit. This is how it's taught if you personally believe that, like, the rule of law is important. If you personally believe that these, like, institutions are infallible. If you personally believe that, like, I don't know, that these guys are genuinely operating on a fucking institutionalist framing. You know what I mean? Which is bullshit. I mean, institutionalist, sorry, textualist or originalist framing. And it's bullshit. But it's important to fucking, to comprehend this because, like I already yelled about, they're not even abiding by their own terms that they've set. So it doesn't even make sense from that perspective. Why rest in piss, RBG? I honestly don't know. Because she is a selfish piece of shit who refused to fucking retire under the Obama administration when there was a literal filibuster-proof supermajority. Okay? And she refused to retire. People were pushing for her to retire. Her and Breyer both, actually. And she said no. She had cancer like 9 times at that point, man. God wants you dead. Dumbass. God wants you fucking gone, dude. At that point, you have to retire if you truly care about the future of America. If you care about the future of women. Okay? Just go and fucking die in a corner. What the fuck is wrong with you? Libs ain't gonna like that one. Libs can suck me from the back and the front, okay? Liberals can come in here and suck my cock from the back. What the fuck do you mean? Oh, libs are not going to like this. I'm sorry that I'm fucking, tipping some sacred cows here for liberals. Like RBG. Just as dumb as a fucking cow. Institutional fetishists need to realize that the Federal Society didn't contrive originalism in a vacuum because it was a good idea. They created to provide cover for a regressive political agenda. Exactly. Originalism is a relatively new way of interpreting the Constitution, and it was created as a counterbalance, a counterweight to the living, breathing document mentality, okay? And the reason why they created it is so that they could hide their reactionary politics under an intellectual, pseudo-intellectual patina. That's it. That's the main purpose. Couldn't the GOP have blocked the nominee if she retired? No, they couldn't have. What the fuck are you talking about? What? Wait, what is this? The most hated of men to Allah is the most quarrelsome of opponents, as in debaters. This is literally a hadith of Prophet Muhammad. Yes, thank God, dude. Obama could have picked some moderate who'd vote to remove Vo. You never know. Wait, what? No, that's crazy. I was in high school when RBG was still alive and we were taught that she was a girl boss. Yeah, dude, totally.
Constitutional law professors filed amicus briefs arguing that the right to an abortion is rooted in the Equal Protection Clause. But Justice Alito said that the Equal Protection Clause is inapplicable because the court had already ruled that abortion is not a sex-based classification. Justice Alito rejected calls to preserve Roe and Casey because of stare decisis. He said that the concept is not a straitjacket when a ruling is grievously incorrect, and listed other landmark decisions which upended precedent like Brown versus Board of Education, which overruled Plessy versus Ferguson's separate but equal doctrine. And then there is stare decisis, the idea that the court should follow precedent to foster predictability unless it has a very good reason not to. And in assessing whether stare decisis applied, the court looked to several factors: the nature of the court's error, the quality of the reasoning, the workability of the standard, its effect on other parts of the law, and reliance interests. Justice Alito said stare decisis was not applicable because the original Roe decision, as modified by Casey, is, quote, egregiously wrong. In support of its decision, the majority opinion cites 30 other cases where the court has overturned prior precedent. As to the 5 factors, Justice Alito said that Roe was fundamentally unfair because it foreclosed the opportunity for anti-abortion advocates to lobby their government for change. Quote, those on the losing side, those who sought to advance the state's interest in fetal life, could no longer seek to persuade their elected representatives to adopt policies consistent with their views. Though the statement ignores the decades of lawmaking around abortion, where legislatures passed abortion restrictions in response to the democratic process. And as to the workability factor, Alito said that as a practical matter, the undue burden test was too confusing to apply. Though he also criticized Roe's original trimester framework as being plucked out of nowhere. And in a stunningly short section, Alito wrote that overturning the precedent—
I mean, that was considered for viability outside of the womb at the time, no? Like, that was what it was. Which, yeah, as medical technology improves, would actually undermine the legal protections afforded by the Constitution of the past. But still, the ultimate goal this is all made up. That's it. That's my answer. Ultimately, this is all made up. You're making it up to take these fucking rights away from people. So just make it up in a way where it fucking suits your needs to give further rights to these people. Parasocial diet soda jab to the heart. Eat some more carbs. Lol. BBL. Fake news. Dude still getting paid. QAnon ARG guy. Stop getting paid. Lol. Dumbass hacker. Chat, sorry for saying I hated you just on days when we get closer to pro rapture shit. What? Okay.
would not hurt women because there's no evidence that women rely on the right to abortion in living their lives. He said, quote,
yeah, no, totally. There's no evidence, dude. Oh, wait, like, if you look at the Guttmacher Institute, there's plenty of evidence, dog. What do you mean? 4 million women every fucking year have irreversible, lifelong complications, which includes death in that number as well, from getting back alley abortions. All matter of empirical evidence also points to the fact that when you fucking make abortions illegal, you're not stopping abortions from happening. You're just making people get abortions in back alley abortions, which is dangerous.
Quote, conventional concrete reliance interests are not present here. And he concluded that the right to an abortion had nothing—
Homie said pregnancy has, yeah. I mean, basically, he said pregnancy. Genuinely don't know what the Federal Society is. Not gonna lie. It sounds like some conspiracy shit. My favorite is the guy who just doesn't know anything and comes in here and is like literally hearing things from the guy who does know at least some things, okay? And goes, must be fake. How are you any different than a Republican then? At that point, how are you any different than the people that you probably perceive to be like dumb hogs when you are just a dumb hog yourself? Just Google it, homie. It's free. I've talked about it so many fucking times on this broadcast, but like specifically if you're like, oh man, this seems kind of fake to me, then look it up. Oh.
In common with other types of interests that people rely on, like contract and property rights, because abortion is unplanned. And he said that if women really think they rely on the right to abortion, they should.
Sorry, I don't watch it every day. Okay, but like, examine the part of your fucking brain that immediately thought this must be a conspiracy theory. Just look it up. And then also look it up. Please look it up. Jenilyn Miari. Oh, shit, dude. Boys, we got a new sugar mommy. Thank you, Jenilyn Miari, for gifting 50 big ones. They're on their way here right now, by the way. They're going to be here soon. I also ordered food ahead of time. Okay? You can't realistically expect the chatter to do the most basic research before asserting that you are the one who was wrong. Yeah, well, it seems... Well, Dr. Paxmore, have you perhaps considered that it seems kind of sussy? Like, what I'm saying seems kind of sussy? And, you know. The Gordo, thank you for the 20 gifted subs. Damn, boys. 70 people are no longer seeing the top of the hour ad break. Think about that. If you're not one of those lucky 70 people who just got an opportunity to avoid the top of the hour ad break, which is coming right now, well, then let me tell you, there are other methods. Like, for example, you can subscribe for $5. If you don't have $5, you can subscribe for free dollars, free 99. How can you subscribe for free? With a Twitch Prime. By connecting your Amazon Prime account to your Twitch account, you will get one free Prime subscription a month. Okay? What is happening? Peach Jars with 25 get the subs. Guys, why are you gifting me subs? Ronald, thank you for the 5 gifted. Great Scott 1605, thank you for the 5 gifted. Math Life 314, ew, Math Life 314. Thank you for the 5 gifted. Here's the 1 minute ad break now. Socialism is when no fun. Thank you for the 20 gifted. You're wrong. Socialism is when fun. We're going to have some fun right now with literally 2 of the people that just gifted a fuckload. Okay, all right, let's continue.
Dismissed generalized
The
issues
Gordo with another 50. Timothy Champagne with a 5. Jesus Christ. Okay, stop. Stop. Is VC. Thank you for the 10 gifted. What is this? UV a chatter? Who produced Skeleton? Just curious because that beat is heavenly. Edit what the fuck I started. Google it, simple. Delete this and fuck off now. All lead the bear cat. Thank you for the 5 gifted.
By saying, quote, the court is ill-equipped to assess generalized assertions about the national psyche. Now, obviously, 4 other justices, Roberts, Sotomayor, Kagan, and Breyer, criticized the majority for overruling 2 long-standing precedents. Justice Roberts' concurring opinion, which we'll talk about more in a second, supported upholding Roe because of stare decisis. And meanwhile, the dissenters disagreed with the majority's conclusion.
Genuine question. Don't conservatives say this about guns too? Won't the bad ones just get it illegally? Won't the supply? I don't mean offense. No, that's a great question. It's one that is commonly asked. It is a complete bullshit because, hey, guess what? A fetus can't be fucking born without the carrier. But last time I checked, you were not born with a gun attached to your body that, you know, you can remove on your own. Like, this is a commerce. You're confusing basic biology with commerce. Arya Saka T 99. Thank you for the 5 gifted as well. All right.
That it can reverse these abortion cases without undermining other fundamental rights. They wrote, quote, "Think of someone telling you that the Jenga tower simply will not collapse." However, Justice Alito addressed their concerns by stating that the right to same-sex intimate acts, the right to contraception, and the right to same-sex marriage were quantifiably different than the right to an abortion. Unlike those rights, abortion terminates a human life. It affects, quote, potential life, whereas those other rights do not. He said, quote, "Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion." Though it should be noted that this distinction between rights that implicate potential life is not in the Constitution and is not particularly well supported in this context. Justice Alito goes on to say that since abortion doesn't implicate any fundamental right, then Mississippi's law should not be judged according to the heightened scrutiny that the court affords fundamental rights. Instead, the majority opinion says that abortion restrictions should be judged using the rational basis standard of review, which is the most lenient standard of review. Basically, almost no law ever fails rational basis. Now, it's relatively easy for state laws to survive rational basis scrutiny, and the laws are upheld as long as there is a rational basis which the legislature could have thought it would serve the legitimate state interests. And Alito had no problem finding that Mississippi's statute met that standard, since it asserted the state's interest in protecting the life of the unborn, and because it regulated the medical procedure that is generally used for abortions after the 15th week. And therefore, the opinion concluded the abortion provider's challenge to the law had to fail. And the Alito opinion did not analyze a woman's interest in obtaining an abortion after 15 weeks of pregnancy because, under the rational basis review the court outlined, it wasn't necessary to a determination of this case. And that takes us to the Roberts concurrence. Now, the concurrences and the dissents do not carry the force of law. There was a majority for the court, and that is now the law. But examining these other concurrences and dissents is interesting to let us know where the court might be going in the future and what the other alternatives were.
Not a good place.
With respect to the Roberts concurrence,
Spoiler
Chief
alert,
Justice
not
Roberts
good. Not a good
agreed with
place.
the decision to uphold the Mississippi law, but he would have done so without formally overturning Roe and Casey. Roberts was prepared to uphold the constitutional right to an abortion, but he would have eliminated the viability analysis that was in place in Casey. He would have characterized Roe and Casey as adopting two distinct rules of constitutional law: a woman's right to end a pregnancy and the state's power to override a woman's right when a fetus becomes viable. Justice Roberts said that the viability line, quote, never made any sense. The right to terminate a pregnancy should, quote, extend far enough to ensure a reasonable opportunity to choose, but need not extend any further. Roberts briefly surveys international law and concludes that the general proposition is to allow abortions until around 12 to 15 weeks, without regard to the viability of the fetus. Roberts also points out that Mississippi did not ask the court to eliminate the right to an abortion. The basic request was straightforward. He wrote that it was to clarify whether abortion prohibitions before viability are always unconstitutional. For Roberts, all of these factors indicated that the best way to balance the interest was to use judicial restraint. He would have eliminated the viability.
Again, I just want to point something out. Viability outside of the fetus is not a good determination for when a pregnancy will be forcibly carried out to term. Why? Because medicine improves regularly. Okay? A viability outside the womb for the fetus. Sorry. Viability outside of the fetus. Viability outside of the fetus is something different. That is when a fetus can, make a sandwich. And if it can't, then fuck that fetus. Kill it. Okay? If it can't feed itself, then it doesn't deserve to survive.
Standard, but upheld the right to an abortion. Justice Roberts first suggested this compromise during oral arguments, but he was unable to sway the 5 other justices. Then there are the concurrences from Justices Kavanaugh and Thomas. Justice Brett Kavanaugh said that in his view, the Constitution is neutral on abortion. Since the Constitution is neutral, then, quote, this court must also be scrupulously neutral about abortion. Kavanaugh emphasized that the court wasn't...
Notice that, everything we're reading about the fucking concurring opinions are just basically, okay, I'll explain this one more time. Everything that we are reading currently on the concurring opinions are all ways to shield people like Brett Kavanaugh and shield people like Justice John Roberts from getting scrutiny for enacting the most reactionary fucking sequence of events. Okay? Understand that these people are using all of these technical terms, or they're using these, legal justifications, with the express purpose of trying to make it seem as though they're not just implementing a really fucking bullshit conservative rule of law. That's it. Get it twisted. Don't get an abortion. Please start having sex. A child is an investment in your future. The child will make change. You will win. You will do all of that. You understand? You will get a snobby little shit and destroy your fucking life. It is. It's mental gymnastics. All of this is mental gymnastics. Who gives a fuck if you're saying the Constitution is supposed to be neutral on abortion? If the Constitution is neutral on abortion, or if you think that there is like a legal tradition, or it's a normal part. If you're a strict textualist, originalist, and you believe that like the Constitution was neutral on abortion, it implies that like they didn't care when abortions were happening. And if that's the fucking case, then you can't allow states to make laws to restrict people from having abortions. Because that would imply there would no longer have neutrality in that circumstance. Because there is no neutrality when someone is saying, no, we're going to take those rights away.
Outlawing abortion nationwide and was instead leaving the decision to the states. He wrote that the 9 unelected members of this court do not possess the constitutional authority to override the democratic process and to decree either pro-life or pro-choice abortion policy for all 330 people living in the United States. The rest of Kavanaugh's opinion was designed to reassure people that this wasn't a radical opinion that would upend other cases like Griswold and Obergefell. And he anticipates some of the major legal issues that are probably coming, particularly whether a state...
I've said this before, and I will say it again, okay? If you are an originalist, I should be able to kill you in a duel, okay? That's how shit was done back then. If you're an originalist, if you fucking get a cut, you have to get gangrene and die, okay? There is no medicine for you. You can be an originalist, but you cannot take advantage of modern medicine while simultaneously claiming that you are an originalist, okay? No shot. No fucking shot. We have to treat you, okay? No more vaccines. We have to literally treat you with the medicine of the time. I'll put some... Oh, sorry. Did you get shot in the fucking duel where I killed you with my musket and you're bleeding out? Well, guess what, dude? Here, we'll stick some fucking leeches on you, okay? And strap you to a barrel full of heroin and then let God sort it out, motherfucker, okay? They'd be like, no, I've been shot in my chest. I'd be like, nah, I'm cutting your arm off. Why are you doing that? I don't know. It's just, cutting your fucking arm off, dude. Sorry. People are failing to understand the tactics used. Those fascists are taking away people's rights while also making teens more afraid to have sex and increasing the chance of generating more incels who turn easily into neo-fascists. Okay, dude. No, they're not doing it for that reason, okay? This is not 5D chest for incel neo-fascists. What? Yeah, dude, they want more people to flood the fucking anime convention, dude. That's what they want. Listen, you don't understand. This is 5D chess, dude. How much... You have, like, horse blinders on if you legitimately think that the Supreme Court justices that are, like, 800 fucking years old and the Federalist Society that has been, like, at this exact same fucking... vindictive agenda since 1982 was doing this so there would be more people frequenting fucking 4chan poll. Yeah. You don't understand. This is an elaborate ploy to make Discord mods.
It can ban its residents from traveling to another state to obtain an abortion, or whether a state can retroactively punish people who had abortions. He says that these are not hard questions. The answer to both of them is no. Though this is just a concurrence. These answers in this concurrence have no legal weight since these questions were before the court and no other justices agreed with his conclusions. So that takes us to Thomas's concurrence, which is sort of the opposite of Kavanaugh's concurrence. Justice Thomas wrote a concurrence to state that while he agreed with the majority opinion that there was never a due process right to abortion, the court should also make it clear that there was no such thing as substantive due process at all. Justice Thomas believes that the Constitution's Due Process Clause only addresses the processes the government uses before taking a person's life, liberty, or property, and it has nothing to say about the substance of the person's rights. He left no doubt about what he thought about rights to gay marriage, contraception, and same-sex intimate conduct. Quote, in future cases, we should reconsider all of the court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. Though critics noted that Thomas did not address the similar case of Loving versus Virginia, the case that legalized interracial marriage and protects the legitimacy of Thomas's own marriage, it's hard to square a deeply rooted analysis with keeping Loving versus Virginia intact if the court is going to go after the rest of the unenumerated rights cases. However, Loving was also grounded in equal protection. It is related to, but not totally dependent on, the substantive due process cases he wants to overturn. That takes us to the dissent of Justices Breyer, Sotomayor, and Kagan. The dissenters critiqued the majority's claim that they were simply returning the issue to state legislatures where it belongs. Quote, we believe in a constitution that puts some issues off limits to majority rule. In other words, the dissenting opinion warns that it is dangerous for the majority to have total control over minority rights. The dissent rejects Alito's claim that Roe and Casey just randomly appeared, that they came from nowhere and went nowhere. This, they write, is not true. The dissenting opinion takes issue with Alito's statement that Casey and Roe didn't allow courts to even consider whether the state has an interest in promoting life. And the dissent says that part of the reason that Casey departed from the Roe trimester analysis was because the court recognized that after 2 decades, the Roe framework did not give states sufficient ability to regulate abortion prior to viability. Quote, the strength of those state interests is exactly why the court allowed greater restrictions on the abortion right than on other rights derived from the 14th Amendment. The dissent goes on to say that, quote, what Roe and Casey also recognize, which today's majority does not, is that a woman's freedom and equality are likewise involved.